I've counseled women and a few men on how to get the other side thrown out of the house.
How hard is that to do?
If you follow my instructions, easy.
It's unethical. It is unconscionably unethical.
The custody evaluators, for the most part, are a bunch of morons making money off the backs of people who don't even quite understand the system.
Absent a dispute, a lawyer and an acting judge make no money. So the language of legislature involved in any type of state of Minnesota, California, so-and-so, is based on these doctrines in order to determine child support, visitation, and child custody. There are several thousands of people dealing with issue of child custody, child support, visitation right, and have not heard of something called the best interests of the child doctrine. Some have, because there are always exceptions. While the previous section have focused on expressive association, the Constitution also protects certain forms of, quote, intimate association. These protections primarily extend from the personal liberty interest protected by the Due Process Clause. The main problem with bringing a third party into an issue between a couple, especially or regardless of whether or when a child is involved, is the fact that litigations are in their nature adversarial. And while both parents or both couple might assume the other party to be their adversary, and in some cases it might really be the case, one party who brings a claim using a third party through a litigation assumes that the third party, aka the acting judge or the attorney, is acting in their best interest. This is not the case. First, because there's a necessity for the acting judge to look at things in the best interest of the law. In other words, the judicial department, regardless of whether they call it criminal, domestic, civil, family, whatever they label it, is there to, quote, interpret the legislature, governing any particular dispute or allegation that you bring in front of them. So they don't give the slightest care about the man or the woman or the child. Second, it is that robe they put on and that chair they sit in and that room that they do business in is the same as an enterprise. In other words, there is an intent to make money through the casual flow of business. You're right. And that dispute that you say you have with that other party is a business for someone else. And the dynamic of that business, you are foreign to it. Because the dynamic of that business is between the acting judge and the lawyer. As mentioned in prior videos, the working environment of a construction worker is whatever the location is. Maybe it's down the street somewhere. Maybe it's in a highway. Maybe it's underneath a tunnel. Maybe it's somewhere in an alley. The working environment of an accountant is if they work for a law firm, wherever the office is. If they work from at home, their home office. The working environment of a doctor or a nurse, if they're in a private practice, is whatever the location where they're providing the care, or the hospital, the nursing home, the clinic. As for lawyers and acting judges, the working environment, the equivalents of their office, are those courtrooms. So now your right is somehow wedged in between someone else's need to make money based on one thing and one thing only: dispute. Absent a dispute, a lawyer and an acting judge make no money. So they require a form of issue in the personal lives of people to be significant. And humans are social creatures, an emotional creature. We're spiritual first, to which the physical and every other attribute expressed in the physical follows. But in this instance, the social and emotional portion of humans are the primary elements regarded as the tool to be milked and used to the detriment of not just the one you think you're bringing the case against in a dispute between man and woman or a dispute between parent and child. The tools of social emotional attribute of humans are used against both plaintiff and defendant in the matter and anyone else caught in between. If you go into any court case, assuming that you are going to get the upper hand against your husband or your wife, whether you used a child as a leverage or not, whether it's dealing with divorce or not, whether it's dealing with alimony or not, you are sadly mistaken of what the reality is. And when you start to look at the language of state legislatures as far as, quote, domestic matters are concerned, that these acting judges in these circuit courts, and in some jurisdictions they call it district court, basically the lower trial stage courthouses and courtrooms, these languages of legislatures were lobbied by those who intend to make money using it. Therefore, the acting judges are interpreting that which was pushed with money not to benefit you, the everyday man and woman, because predominantly the everyday man and woman do not even realize that they have the right to participate in the creation of the language of legislature based on the First Amendment right to petition, redress, and grievance and the equivalence on each state's levels constitution. 99.99% of every adult will have this sense of confidence, this great big ego about who they are in life as a grown man and a grown woman, do not know this, and automatically kills their ability to even stand up and speak up where a third party is involved with what they assume to be their right, or the legal enforcement of those substantive rights affirmed in the Constitution have been lobbied so far away from the spirit of the law of that principle in that Constitution that the man or woman doesn't even know when it was lobbied, when it was passed, what the intent is on the congressional level, or what the effects are, until it is too late. So now here you have Jane, here you have Sally, here you have John, here you have Bob filing paperwork because, well, they see their partner as an adversary in a private, personal relationship where everything was otherwise easy to fix. The moment they bring a third party called the courtroom, the courthouse acting judge, and an attorney into the equation, they get pulled into a whirlpool that they cannot swim against its current. Because these courtrooms, if you are having personal relationships, I'm not speaking about someone who really did something torturous towards you. I'm speaking about a personal relationship because you have this emotional, social thing going on amongst you two, to which that courthouse is not meant for social service. That courthouse is not meant for emotional assistance. Instead of you taking care of it privately, and one fails to realize that these courtrooms are built and sustained on dispute for someone else to make money, that is the moment you have just effectively placed yourself into several decades. Most people don't realize it. Several decades of headache, loss of money, primarily because most people don't even know what asset protection is. They don't know how to protect that thing called a social security number that's used to track them. They don't know how to create separate records and personhoods. They don't know how to preserve the integrity of their own privacy in daily life using contract and trust. And even worse, most people don't realize that most of these venues are based on the element of self-confession, one of the primary things that will be done with you, regardless of whether you think you're the one seeking restitution or remedy against someone who you think is an adversary, until you realize a few years later, and if you're sharp enough, a few weeks or a few months, that there's a bigger devil in the equation and you would have been better off not involving it, you would notice that one of the first few things they would try to compel you to participate in is something relating to financial statements. They are now assessing you like a tax assessor would look at the value of the land and the apartments attached to it to determine what the property tax is. No different than a fighter would size up another fighter to see how well they can leverage and quickly end the battle or prolong it for the purpose of some sadomasochist tendencies. The same is done on pen and paper, and people just casually go along with it because it's presented to them as the normal course of that which they think they are there to get from the third parties. They are sadly mistaken, because the entire point is to make as much money from you, regardless of whether you say you're the victim in a personal relationship or not. Even worse, if there's a child involved, they don't look at you and what you say. They don't look at your facts. They don't care about that. What matters is what makes the most money. Now, there's a general undertone that the attorneys are funneling money to the acting judge in order to increase the odds of winning any case that they have in front of any given acting judge through campaign contributions, which I show in the slush fund webinar, how to find it, and most importantly, how to separate yourself from these courthouses by separating certain things when it comes to the social security number. And I show how to use trust to protect certain things in all these other videos. Besides those undertone on both end of theirs and yours, if the child is involved, that child will be used against you. Do you have the constitutional right to intimate association as affirmed in the First Amendment of the federal Constitution? Yes, as follows. Within the United States Constitution. First Amendment. Congress shall make no law respecting an establishment of religion. That's one clause securing one principle by affirming it, or prohibiting the free exercise thereof. That is another. Or abridging the freedom of speech. That is another. Or of the press, yet another, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. A naked eye will read this and think, wait a minute, this speaks nothing of right to association. But it did. And in fact, we've just read this. And this simplicity is called legalese, where it is expected that you would read something, you would go over the exact thing that applies to you, yet you will not see it. This reality is what these acting judges and attorneys rely on. And even if there is a slight chance that you have a little bit of problem solving skills through emotional intelligence, spiritual intelligence, and logical intelligence, that you might eventually have the reasoning and deductive and inductive skills to stop and think about these and maybe even do some research and then do some self-reflection on it to figure it out. They would engage in certain active hypnosis, primarily through assumption of authority and dominance and repetition, by speaking with you in a certain way otherwise, where even you will be convinced that you really don't know what's going on. And what is clearly on his face, since someone else tells you otherwise, since someone else tells you it doesn't exist and you don't have it, then it must be so that you don't have it. But in truth, the right to intimate association has its root in the right of association. The right of association has its root, belief or not, and the right to have your own religion. Congress shall make no law respecting establishment of religion or prohibiting the free exercise thereof. This second clause, or prohibiting the free exercise thereof, is called the Free Association Clause. And this Free Association Clause is not just confined to religion. It is confined to family. It is confined to contract, which for the most part is what any type of civil or criminal matter deals with. Is not confined to personal relationships. It is any given circumstance under any condition. The amusing part is it is used against you every day and you don't even realize it. When your employer say they have the right to fire you at any time, that's right of association. When a business say they want to trespass you from a place despite it being open to the public and there being standard tests and elements associated with that, that's right of association. When someone tells you, you must put this thing on your face, otherwise you cannot purchase this or come here, that's right of association, albeit there are standard tests and element. If a body polity or a business is using it against the everyday man and woman. The same applies with a third party called the courthouse of so-and-so, the circuit court of so-and-so, the district court of so-and-so, trying to take your children away from you or determine the extent of liability or association between you and your partner. You have a power so much. Your sovereign immunity is affirmed within this amendments, these bills of right, so much that the standard for you when you are enforcing it against someone else is assumed to favor you. In other words, if someone says you must do something such as maybe insert certain animal substance or the laboratory artificial or the laboratory synthetic made viruses inside of you under some false promise that it's supposed to do something for you, you have the right to association with those people saying you have to do one thing or the other, especially in circumstances where there are no legislatures that mandate it. And even if there is, you have the right to redress of grievances to rule that unconstitutional based on free speech. So in this particular instance, where we entertain the issue of right of association, to which intimate association between man and woman, parent and child, flows from. We'll be looking at congress.gov. We'll be looking at constitution.congress.gov, particularly one of their web pages under Amendment 1.8.5, Intimate Association. These are the foundation you must have in mind under any circumstance, regardless of what stance you take as to what the objective things are. Remove social elements. Remove social elements and remove emotional gratification from it, and look at things from a objective standpoint and stick to it from start to the end, no matter what. On the patron page, I've went over the 7 laws of hypnosis are used in courtrooms. It would benefit you to know about them, but that's not what we're here to focus on. First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for redress of grievance. Interesting. So what does constitution.congress.gov have to say about right of intimate association, derived from First Amendment. While the previous section have focused on expressive association, meaning religion, your ability to speak a certain way, if you speak for or against something, whenever you speak, it's usually in two dichotomies, for or against something. When you speak for something, you're associating yourself with it through that speech. When you speak against something, you're disassociating yourself from it through that speech. You see how freedom of speech is linked to the right of association? While the previous section have focused on expressive association, the Constitution also protects certain forms of, quote, intimate association, unquote. If we are to go to some of the reference provided here, they give us the res judicata. This is some of the ways that I actually find res judicata to use, not by Chat GPT that hallucinates and gives you some quotes that sounds very good and very appealing based on the prompt you provided it. And most people don't take the time to take those quotes and do independent research to realize it doesn't even exist. And they quote it everywhere else, and God forbid they even use it. And hopefully you don't even try to use it in an actual court cases, because these people on the other hand, the acting judges and attorneys, they have access to portals and platforms that easily have encyclopedia and filters of certain res judicatas. And if you put up a fake one, that's the quickest way for them to realize in their perspective that you're an idiot. I'm not saying you are, but they already assume and presume you are. And when you start citing fake quotes from fake hallucinated cases because you think you have technological luxury, which by the way is not equivalent to technological advancement, that through your own independent act affirms their assumption of idiocy. If you want to cite case laws in 21st century age of technology, do not rely on some hallucination. Do not rely on some bots who has been designed to hallucinate, deliberately to hallucinate. Most assume technological luxury is the same as technological advancement. I keep reiterating this, that to the contrary, it is not. Just because you have access does not mean you know how to use it. Just because it exists does not mean the one who placed it into existence for your use gives the slightest, excuse my language, does not mean they give the slightest fucks about you. Realize that and learn to do research properly. So if you want to know about intimate association, they give you the case law involved. Roberts versus USJC 468, volume 468. 609, 618. Right here. You can go to it and read the actual case law released by the Library of Congress when it comes to intimate association. So for those on Patreon, I'll be uploading this for ease of access. And on the note of ease of access, let's quickly go over a few verbiages from this same res judicata that reads as follows. Our decisions have referred, our decision meaning the Supreme Court of the United States. I've made another video as to how to read these funny citations when you see a name versus another name, comma, a number, U.S, or whatever comes after this, like APP dot, when it comes to the volume and the page and all that. So at this point, I assume if you are watching Subtle Substance video, you already know how that works. So our decision refers to the Supreme Court decision of the United States. Our decisions have referred, meaning there's been prior decisions, meaning there's been prior decision, aka stare decisis, regarding the same issue that is merely being reiterated here and reaffirmed, but particular to the incident that comes before that comes forth in this case. Our decisions have referred to constitutionally protected, quote, freedom of association, unquote, in two distinct senses. So there are two particularities when it comes to this verbiage. Freedom of association, there in First Amendment. In one line of decision, the court, that is the Supreme Court of the United States, has concluded that choices to enter into and maintain, in the beginning and thereafter, certain intimate human relationships must, not probably, not conditional, not maybe, must be secured against undue intrusions by the state. State meaning the court of so-and-so, acting judges that work for the courthouse of so-and-so. State meaning the courthouse of so-and-so, the trial stages, appellate stages, and the attorneys who are giving campaign contributions to the acting judges that hear those cases, that subsequently create orders, that subsequently create paper trails that says you can't see your child, or you can only see the child for this particular amount because we say so, and well, there might not be any proof, but someone said that you're a bad human being, therefore, oh well. Or there's something called interest. There's something called the best interest of the child, so we'll just speak for the child, and you're the parents, don't worry about it. Since you're here to bring us into the case, we're going to speak for the child because that's the assumption here, because otherwise we wouldn't be here. One of you brought us in here, so that means you've given us the ability to play the role of the parent, because obviously you cannot. That is the undertone. And that is, quote, state. When you look at the formal definition of state, it is the same as interest. And it is the same as estate. Particularly this text from a concise etymological dictionary of the English language by Walter Skeet. Estate, of status, comma, state, semicolon, C, state. I've went over this in other videos. So let's go back to the point of this particular video. But keep in mind, every time you see the word state, is referring to any other party that has interest. And the particular subject matter here is the interest of your association with another human being. So freedom of association exists in two distinct senses. In one line of decision, the court has concluded that choices to enter into and maintain a certain intimate human relationships must be secured against undue intrusion by the state because of the role of such relationship in safeguarding the individual freedom that is central to our constitutional scheme. In this respect, freedom of association receives protection as a fundamental element of personal liberty. So that is the first portion right there. Freedom of association sees and expresses itself based on right to privacy among private individuals without a third party, a body politic, aka state, coming in to assert their own interest in your private life and association and affairs with other humans. In another set of decision, the court has recognized a right to association for the purpose of engaging in those activities protected by the First Amendment: speech, assemble, petition for the redress of grievance, and the exercise of religion. In other words, things you can do collectively, such as assemble, such as hey, I'm inviting you to come join the patron page. Not only do you get access to documents, posts, and videos that you will never find on any other platforms, you also get instant access to webinars that otherwise will cost far more. And we speak of things that usually we would not be able to speak of on any other platforms far more freely. On top of that, you get the opportunity to send me monthly questions tied to theological belief or culture, or coming together to follow particular texts aka religious instructions and beliefs, or family instructions and beliefs, which if you're smart, you would also tie it to religion. So there's a collective right of association and there's a private right of association, is what this is effectively telling you. I want you to really pay attention to what we are showing here, not based on some prerogative, but based on the text itself that is objectively expressing these facts to you. Again, I'll be taking this and putting it on Patreon, but for those not on Patreon, I'm sure you can always find it because you've seen how I got to this document. The Constitution guarantees freedom of association of this kind as an indispensable means of preserving other individual liberties. So you see now that the right to associate is inevitably linked to other substantive rights. The intrinsic and instrumental features of constitutionally protected association may, of course, coincide, meaning the right to association link to other rights, as aforementioned. In particular, when the state, meaning a third-party body politic, interferes with individuals' selection of those with whom they wish to join in common endeavor. I don't know, maybe such as someone telling you the mother gets 10% of the time to be spent with a child, that the father gets 90%. Oh, and by the way, since the father gets 90%, the more time you spent with a child, the more money you now have to pay. So the father is happy you get to spend 90% of the time with a child. Ha, in your face, wife. But then the acting judge says, now you got to pay 90% of the cost and also pay the woman too. So who's really winning? Both the father and mother are losing because that child needs both the father and mother in their life. Lest the child have some emotional dent and a sense of being incomplete that they will perpetually seek through their adolescence, teenage, and adult years and will never find, because the neural pathways in the mind is based on how we associated with those immediately in our household, and that shapes how we interface with the world. Some people spend 5-6 decades before they even get a glimpse of probably figuring this out, with a lot of emotional damages and more, financial and so on forth, so etc. So you see the damage of a body politic, a third party's interference with your right of intimate association goes far beyond what you see on a surface mundane level. This is how that same child would give birth to another child and perpetuate that trash, and it gets worse a generation after the other. And each generation that gets born into that trash would never realize that there's a condition better because that's all they've known. And they see reality just that way. Those same children end up being lawyers, accountants, doctors, in order to prove to themselves that they are sufficient enough based on what they've lacked, either because of the sins of the grandfather or the grandmother somewhere where they screwed up by bringing a third party, which created a chain effect. And then those children now who are damaged, who are going to be in certain positions of influence in society, sees the world the same way, and they perpetuate that damage in the act of trying to feel sufficient in themselves by taking over other people's lives as control. If they were to get the opportunity to look at some magic crystal ball or maybe go on a ayahuasca trip, they'll realize, oh shoot, this same thing that they're doing to others was done to them. And preconsciously they're trying to return to it. You see that these things become quite profound, albeit most people don't like to look at it from that perspective and assume it to be just confined to social and emotional expression only. It's more than that. If you ever look around in the world and see why it's slowly turning into a surf planet, the lack of humans to sustain intimate association without allowing a third party to screw their lives over. This is the reason why. I'm here to tell you, look, doesn't matter what you think that other party did to you. That is either your wife, your husband, your boyfriend, your girlfriend. Label them whatever you want. It doesn't matter. If you get a third party to make a decision for you, that is the first stage to destroying everything valuable that you have in your life by your independent waiver. And this is another thing with constitutionally secured right or any right or obligations. You can waive it. The moment you bring a third party into the situation, you have waived the right to intimate association. This is the reason why they can just railroad people in, quote, family court or, quote, domestic court. Because your right of intimate association, you have voluntarily gone to a third party to meddle and interfere with it. Keep third parties out of your business, no matter how spiteful you are to that other party, because at the end of it, you will really not benefit from it.
It's insane.
As long as you treat your family well and there's not anything going on criminally and there's not some abuse, the state doesn't get involved. But for some reason, when you file for divorce, a whole bunch of strangers are starting to look up your address. You need evaluators, you need psychologists, you need all these people to tell you what you did wrong. I will never understand that.
A parenting evaluator, you conduct all sorts of tests, personality tests, and then make a recommendation who should get primary custody of the kids.
It's unethical. It is unconscionably unethical.
The custody evaluators, for the most part, are a bunch of morons making money off the backs of people who don't even quite understand the system.
I mean, it's the most widely used test in the country, but it is not a reliable test. And showing you a bunch of ink blots, what's this look like? What do you see in here? And then scoring you for narcissism or, defensiveness or paranoia because you see bats and butterflies and birds is not based on science. It's unethical. It is unconscionably unethical.
As a parenting evaluator, you don't have to be good at understanding the human condition or knowing who would be a better parent.
In the old days, you could get those evaluations for anywhere from $2,500 to $5,000, more typically $5,000 to $7,500. Now I'm seeing them $35,000, $60,000. They're very expensive.
So it really shows you so often what matters is not the relationship between the children and both parents, but money.
In Miss Singer's case, there was a particular bank account that had liquid funds. Once the court sees the financial picture, it says, now I know I've got money to work with.
You said that in court.
On the transcript, sure, on the record.
You have a big leg up in keeping the kids and maybe keeping possession of the house.
I've counseled women and a few men on how to get the other side thrown out of the house.
How hard is that to do?
If you follow my instructions, easy.
The intrinsic and instrumental features of constitutionally protected association may, of course, coincide, in particular when the state interferes with individual selection of those with whom they wish to join in common endeavor. Freedom of association in both of its forms may be implicated, meaning with individuals or as a collective. The JCs contend that this is such a case. Still, the nature and degree of constitutional protection afforded freedom of association may vary depending on the extent to which one or the other aspect of constitutionally protected liberty is at stake in a given case. We therefore find it useful to consider separately the effect of applying the Minnesota statute to JCs on what could be called its members' freedom of intimate association and their freedom of expressive association. In other words, this freedom of association is looked at case by case. While the previous section have focused on expressive association, the Constitution also protects certain forms of, quote, intimate association. These protections primarily extend from the personal liberty interest protected by the Due Process Clause of the 14th Amendment, which also exists in the 4th, but the 14th Amendment is the incorporated versions in order to allow any type of corporate persons to be involved, which the court has construed to include an implied, quote, right of personal privacy. The relationship, quote, entitled to this sort of constitutional protections, unquote, are, quote, those that attend the creation and sustenance of a family. Isn't this the main thing that is supposedly to be entertained in what they refer to as family court? So if it's family court, then there's a general assumption that the primary thing that ought to be perceived, or the lens used to perceive the issue brought into family court, ought to be the First Amendment right to intimate association. Why? Because the right to intimate association are relationships, quote, entitled to sort of constitutional protections that attend the creation and sustenance of a family. But is that really what's going on in family court? To the contrary, based on the first few things mentioned in the beginning of this video regarding the relationship of attorneys and acting judge, and recently mentioned with people waiving their right by bringing a third party, including those formed through marriages, childbirths, child rearing, meaning how you develop that child, what you tell that child to do, how you discipline the child, which school that child attends, which there are several case law affirming the same also, which is best done through religious instructions of belief rather than just your mere feelings. That way you can have it fettered and hinged on something that is constitutional, in addition to intimate association and cohabitation with one's relative, meaning who spends time where, when, how. Those constitutional liberties are discussed more fully elsewhere in constitutional annotated. If you scroll to the bottom, they give you all the rest of the coda from where those codes are. Someone dealing with such a circumstance as family court regarding cohabitation, meaning who gets to spend time with the child, or when, where, how, child rearing, meaning who spends what, and how they discipline the child, childbirth, marriages, whether it's dealing with divorce or not. All they have to do is just look at the Constitution, and they will see the things that they need to evoke. All those other personal feelings, he did this, she did this is how I feel about it, all those are absolutely irrelevant, especially when you start to look at the rule of evidence. But how many adults with degrees, with high heels, with expensive perfumes, and with large egos, how many of them realize these basic things? The first stage of killing a right is to not know that that right exists. And that right does not merely exist because it is written down. These things written down are mere affirmations of what intrinsically exists in you. So if the average adult does not even think about these things absent of what is written down, then that means the principle itself and the spirit of it is missing in their own souls. So no wonder it's easy for a third party to take advantage of these adults. But it is never too late to start to study and to look at things, to reawaken that ember, that flame inside of you as to the things that are intrinsic and substantive, that is reaffirmed on pen and paper, so that you can utilize it. Because no one else would do it for you. No attorneys would evoke constitutionally secured right for you when making money from you is what they do for a living. It's that simple. And if you eventually find that, it is extremely rare. Those are extinct species that function contrary to the interest of the British Accredited Registry membership, that function contrary to the interest, commercial interest. And if you look at the history of the shield of some of the monarchs called esquires, you realize their interest is not for the people. All those things regarding massacres of everyday people, where they're told, stay here, don't do this, and they condition them and people do it, and eventually they just come into that place and just kill all of them. Right. And they sweep it under the rug of history. That's what esquires used to do. Look into these histories of the shield. Infrequently, the Supreme Court has considered the degree to which the First Amendment may also protect association and family and the intimate relationship. In Ling versus International Union, the court rejected the First Amendment challenge to a federal law that denied eligibility for food stamps while any members of a household was on strike. So now there are conditions to where you just can't claim right of association to get public benefits. The intimate right of association is meant to be enforced as a private right. The moment you start to engage in saying, hey, you must associate with me, aka give me food stamps, it doesn't extend that far, because it is meant to be exactly what it's meant to be, to retain privacy from third parties meddling in your life. But if adults are not socially, emotionally intelligent, how in the world will third parties not meddle in your life? So I implore people to not let all those sexual instant gratification and impulse of your rubbing tissues screw your life up. When you really look at the origin of what really begun most of the issue that people have when it comes to family court, domestic court, that led them to not even have the concentration and attention to look at fundamentals like this, you realize it is because of the impulse of copulation, the impulse of rubbing tissues, the impulse of simulating the warmth of a mother or the warmth of a father. And it led to a lot of mess. So curb those impulses. Have fun in life, but curb those impulses and pay very close attention to the social and emotional intelligence of the people you associate with. The true family planning, the true parental planning, is based on those two things: social and emotional intelligence. Remove those from the equation and all hell breaks loose. The court reasoned that the law did not violate the freedom of association of close relatives because it did not, quote, directly and substantially interfere with family living arrangements. So it's self-explanatory. Intimate association is designed to be a privately enforced right to retain something private rather than compelling a public body to associate with you. So I'll be uploading all these case laws in the documents, and I'll highlight a particular portion of it to make it easier to study for those on Patreon. For those on YouTube, the link is up here. Go to it, obtain it. Moving on. Besides that, most people waive the right of intimate association by bringing in a third party to act as the parent based on the principles of parents patria. The one who is dragged into it as the partner is supposed to not waive the right of intimate association and evoke it, as that right there is the hammer that they will constantly use and repeat. But at some point, they will be met with a doctrine called the best interest of the child doctrine, as an attempt to subvert the right of intimate association, since one, aka 50% of the parenting, have relinquished the power to a third party to make a substitute decision as a parent. So now there's an assumption of equal footing as that other party who has 50% ability to make decision to say, well, we can now leverage more percentage by saying, well, we're doing this in the best interest of the child, therefore we have more percentage over you. So the playing field is not 50-50 anymore. Remember, say the mother opened the case up and therefore gave her 50% portion of parenting power to the acting judge and their attorneys. Now they will bring in the child based on the best interest of the child doctrine. Really, it's a policy. To now leverage past 100% over the other parent. So what is the best interest of the child? The best interest of the child is a court doctrine used in custody proceedings when two parents are contesting custody of the child. Courts use this doctrine to make decisions regarding which parent will have custody of the child. the nature of visitation rights, and the nature of child support payments. So you see here that under any circumstance that there's child support involved, meaning payments, or there's restriction of who spends what time with the child and when and how long, or any type of matter of who gets the child and why, it is based on something called best interest of the child doctrine. Do you know how many people go through this issue and have not even heard of this doctrine? Because this doctrine is the foundation of why a family court, domestic court, or any acting judge can say, pay child support, can say, here's the amount of time you can spend with your child. Most people go into Social Security Act, Title 4D, because someone has fed them that bullshit as the primary thing to look at. And in their eyes, that's the confines of it. But without this, that whole Title 4D people are looking at with child support and custody issue will not even be effective at all. And even worse, people don't even look at right of intimate association. This should be a red flag. Because that itself, the inability of adults to corroborate this reality behind the issue that they supposedly have, is a clear sign of the reason why the quote system is taking advantage of them. They are so easily misdirected. There are several thousands of people dealing with issue of child custody, child support, visitation right, and have not heard of something called the best interests of the child doctrine. Some have, because there are always exceptions, but the majority of them have no clue, because social media is pointing them to Title 4D of the Social Security Act. A list of factors is often used to make such determination. The list varies depending on the particular law of the state in question, but may include any of the following. So the language of legislature involved in any type of state of Minnesota, Wyoming, California, so and so, is based on these doctrines in order to determine child support, visitation, and child custody. And those basic concepts that those individual state legislatures are sculptured around is the existence of prior agreement between the parties. And please, if you're going to do this, have it notarized and add severability clause and add jurisdictional clause that bars third parties. If you don't have those three principles within that agreement of the party, it's just ink and paper that means nothing. And on top of that, you can optionally have a clause in there that says if one party disagrees with this, you must first go through your own private mediation between both of you. And the other party must give the other party a reasonable notice and give them a reasonable time of about 6 months to come to a conclusion, because everyone still has the ability to leave a contract, but put a due process clause in it. That way you have the time to not be ambushed by some angry man or angry woman who pulls you into a whirlpool where both of you die in it. So merely having an agreement is not enough. The agreement is based on the stipulation. If your stipulations are weak, you are fucked. Excuse my language, but that's the reality of it. Moving on, some of the principles that the state legislatures governing child support, visitation rights, and custody are based on. Primarily the existence of prior agreement between the parties. What is the prior agreement within the parties? That marriage certificate people get, which just only affirms that a third party can mingle in your life and intimate association. Most people, when they get marriage certificates, don't realize they have just automatically waived the right of intimate association. You're just basically saying you don't know how to handle personal, private relationships, and you just need a third party to play God over you. So now you're voluntarily merging church and state with your private life by preemptively adding an entire body polity into your private affairs. Maybe it's 10 years later that it might trigger. Maybe it's 20 years later, but you've begun the issue by buying into diabetic cake and icing of go get a marriage license. I'm not saying there's anything wrong with it. I'm just showing you the objective reality of how it works. You make your decision. The existence of prior agreement between the parties for most people is that marriage certificate and nothing more. So they're screwed on this end because they've enforced no private right of action, no private right of association, no rights and obligation of contract. The quality of the home environment and the degree of parenting guidance that the custodial parents offer, the financial status of each parent, which is aforementioned, they size you up financially to see how much they can siphon from you. The individual need of each child, which they really don't do this, they just make things up. The mental health of the parents, which is contrary to what you think, they're just testing are you socially or emotionally intelligent. If you were, you will start off with this first portion, which is the existence of prior agreement of the parties. The totality of the circumstance, meaning your level of competence and how to remain objective and evoke the intimate right of association. Most people, when they're called into this family court cases, don't even realize they can automatically do a mandamus. They don't realize that they can automatically remove the case. They don't realize it. They don't realize these things. They just go along with it. And preemptively, they don't realize that they can preserve the integrity of their own privacy and their own financial assets. They don't get it. They don't get the power of misinformation. For instance, in New York case Gibson versus Green in the year 2017, the court states that it will look at factors including, quote, which alternative will best promote stability, the available home environment, past performances of each parent's relative fairness, unquote, among other things, unquote. This thing called best interest of the child's doctrine is how people are screwed with child support, visitation right, and custody. It precedes that whole Title 4D thing you hear about that many people just ramble on and don't even know the other things attached to it as aforementioned in this particular video that qualifies it. Even worse, most people don't have their own private contract with a proper clause in it, which is what kills the best interest of the child's policy as the first element considered before they even enforce it. Most don't have such contract because they don't know the First Amendment right of intimate associations. I implore you to start looking at it. The problem, which is quite common, has been reiterated, but the cause, the true cause, beyond the mundane, has been clarified. And believe it or not, the solution has been provided to you. I'll be creating a contract that kills the best interest of the child's doctrine and prevent all the BS when it comes to child custody, child support, and visitation right. And I'll be placing it on the website. Until next time, take care. Best of luck.